Couture, sorry. He is with the firm Atkinson, Petruska, Kozma, Hart and Couture, PC. He is a Alpena native, undergrad of MSU, Go Green, Texas Tech Law School, and is a licensed attorney both in Texas and in Michigan. He's been helping people with their wills and estate plans in Northern Michigan for the last 25 plus years, and is really an expert and is bringing some really great knowledge to us today. Al and his wife, Deanna, have their 3 sons. He also is, he shared that he has 10 brothers and sisters. And so every kind of family dynamic that you can imagine, I'm sure he's seen as well. So he really comes as a great expert. Thanks for joining us today, Alan.
My pleasure, Autumn. Thanks for the introduction. I really appreciate it. So hello, folks. I'm glad you took the time from this beautiful day to spend 25, 30 minutes in a webinar. I think you'll find it informative, at least I hope so, as well as a little bit entertaining at least. So Autumn's had a chance to talk to me about who's speaking, right? So everyone wonders in these webinars, you can see me, I'm speaking, right? So you know a little bit about me, but it made me start thinking about what it was like years ago when we didn't have this fine technology. And that question was asked of this little boy in particular, and I love his response.
Hello, who is this speaking?
Thank you for those words of wisdom, Spanky. Appreciate that. So yeah, Autumn had a chance to talk to you a little bit about me, and I won't belabor the point, but basically I've been practicing law in Northern Michigan here for over 25 years and over 35 years altogether with the time I spent in Texas. I'm licensed in both Texas and Michigan. So, but I'm here. I grew up in Alpena, and I've lived in Gaylord and Traverse City since 1993, so a long time. So I've got Northern Michigan pretty well covered. In my law firm, Atkinson, Petruska, Kozma, Hart, and Couture, we have offices in Gaylord and Traverse City. And one of the downsides of my profession is seems like I've always got a judge telling me to move things along. In this case, yes, Judge Duty, I am moving along. I'm going to get this going. So excuse me, folks. I'm sorry, Judge. All right, we'll get moving into the topics. So what are we going to talk about here today, folks? I thought I'd just outline my chat. And then if you have questions about anything as we go, there's a chat box I think you can access at the bottom of your screen. I think if you send a question that way, we'll get it, and Autumn will get it and make sure I answer any questions you may have. So please take advantage of that. So let's talk about the topics. So the first one is, do you need a will? That's what most people ask themselves. Do I need a will? Or they ask me, do I need a will? So we're going to talk about why I think you do need a will. And keep in mind, we'll talk about most assets do not pass under a will. Most of your assets will not pass under a will. It's basically a catch-all document. It catches things that don't have a title, that aren't otherwise disposed of. So we'll talk about some of those other assets that don't pass under a will, and everything else does. We'll talk about a simple will. That is what most of my clients like to use, and it's what I like to use. It's what my wife and I have. It's a so-called simple will, and we'll talk about what that is and what that entails and why it usually works for most of my clients. It may well work for you. We'll talk about a healthcare power of attorney, also known as a living will in some states, and what that is and why it's important to have one as part of your estate plan or otherwise. We'll talk about financial power of attorneys. They're either springing, so-called springing, or durable. Springing means they come into being when you're disabled, whereas a durable one would be more of a permanent one. So we'll talk about why a financial power of attorney is important for an estate plan, at least to consider it. We'll talk about ladybird deeds and what they are and why they're so helpful to dispose of the family home and why it works for so many married couples. Then we'll go through the basic steps in the estate planning process, kind of rehash a little bit of what we'll already have talked about, but we'll go through the steps in the estate planning process, at least as far as I'm concerned, and it'll kind of get you comfortable with what all is entailed. Answers some of your questions, I would think. And then finally, we'll give you an estimate of what cost for a basic estate plan might run. There's some variability there, but we'll give you an estimate of what a typical estate plan would cost you. So it kind of answers that question as well. So why do you need a will? A lot of people ask me that, and to be honest with you, you do not need me or any attorney to draft your will because you already have a will. It's something called the Michigan intestacy statute. So the Michigan has a statute which says if you die without a will, then your assets will be distributed pursuant to this statute, how the statute says they'll be distributed. I always ask people, why on earth would you want the state of Michigan to decide where your hard-earned assets go on your death? And they will. The state of Michigan doesn't care about you. They don't know your particular situation, but you die without a will, state of Michigan, for the assets that pass under a will, are going to have their last word, and they will tell you and tell your loved ones what happens to your assets. Not a good situation. If you do go without a will and you go under the testacy statute, then you're definitely going to more than likely go to probate court. You can't avoid probate court because it's a statute. It has to be interpreted and followed. So you're going to be in probate court. Whereas with an estate plan, a lot of times you can avoid probate court if that's your goal. So not just wills, but estate plans are more than just a will, right? You receive our advice about the powers of attorney that we're going to talk about, ladybird deeds, trust, anything that goes into an estate plan or estate planning process that you need some advice on or you have questions about, we're there to help you with. So there's more than just a will involved with an estate plan. And then some of you may have older wills now. Well, you may want to update them. They may be 20 years old, 30 years old. I've seen wills 40 years old. Things have really changed in that couple that come in to see me, or maybe one of the couples has passed, one of the spouses have passed away, and things have really changed. So it's important to keep your will up to date. Doesn't mean you got to come in every couple of years, but as things change in your life, maybe you move from one state to another, different states have different laws, that may be a good time to come and get your will reviewed and updated. So the so-called simple will, let's talk about that. What does that entail? Well, a simple will is basically a short, sweet, and to the point way to distribute your assets upon your death. So the wills I typically draft are 4 or 5 pages. Wills can be very complicated. They can be hundreds of pages long. Maybe you want a 100-page long will, but I find that most people like the simpler form. They like to do things straightforward and simple, and it works for most people that I talk to. Just kind of a streamlined will, if you will. It doesn't have to be super fantastic. I have a simple will, my wife and I, so it works for us. It's appropriate for most people and married couples in particular. And what happens is assets are generally all left to the surviving spouse. So the 2 spouses will have wills, and if whoever dies first, the other person gets any assets that pass out of the will. And then when the last person, the last spouse dies, usually they decide they want everything to go to their children. Doesn't have to be that way. You can put whatever you want in your will. That's typically how people dispose of their assets under their simple wills. And the nice thing about the simple wills we draft too is specific bequests, that is gifts, are easily made. If you've got a favorite shotgun or a set of silverware and you want it to go to one kid or one friend or whatever the situation may be upon your death, you can easily do that in the wills that we draft. And if that changes, maybe that person passes away, or you just change your mind on what you want to do with that asset, or you sell it, whatever, you can easily change that specific bequest without changing the will. So it's very simple to do. We'll explain how to do that when you come in to see us. But it's a nice way. You don't have to keep changing the will every time you change a bequest. And you may be able to avoid probate court with a simple will, believe it or not, or at least keep it into a streamlined small estate administration, keep the assets that pass under the will very small. And so it'll be a very short and streamlined process if you do have to go to probate court. Those are all things we can talk about when you come in to see us. Now, keep in mind, most assets do not pass under will. Typically, things like insurance proceeds, right? Because insurance policies control those, and you will have a beneficiary designated in the insurance contract, which says upon your death, your wife gets it, your husband gets it, your child gets the proceeds, whatever that might be. That doesn't go into the will because the insurance contract has a provision for what happens with the life insurance proceeds upon your death. Same thing like investments like 401ks. Almost always you will have a beneficiary designation, someone who takes the asset upon your death, and so it wouldn't go under the will. If you didn't have an up-to-date one though, and if that payable on death provision was out of date, suppose you were leaving everything to your wife and your wife's predeceased you, then there's no up-to-date payable on death provision, then you'd have to go to probate with that asset, because how would the 401k company know who to pay the money to, right? So that's another good reason to make sure you have an estate plan. Will help you with those things. Business and ownership interests and stock, they can or cannot, they may or may not pass under will, but typically there's transferable on death provisions with small corporations, things like that. So typically, especially if you have an estate plan, those won't pass under a will. Finally, bank accounts. Those have survivorship and payable on death provisions as well. When you go in and open a bank account, a lot of married couples have joint bank accounts, but then also they'll have a payable on death provision. So when the last one of whoever owns the account and they both pass away, then you just show the payable on death provision. You bring a copy of the death certificate to the bank, and they'll pay whoever is you've designated to receive those funds. Other options besides just a simple will or a basic estate plan, or including wills and estate plans, is trusts. You can have a trust, right? You can have a will and a trust. A trust costs more money. They're much more complex, but it's right for some people and they want them, and no problem with putting together trusts. And some people like to form businesses, LLCs, to handle at least some of the assets. So some of the assets can be put into a business. We can talk about those things, but they're beyond the scope of what we're going to talk about here today, which is a simple estate plan. But just so you know, there's other options as well. So a little more on the other basic options and basic documents in the estate plan, just to explain a little bit more. The healthcare power of attorney. So this is something that many of you may have now, but some of you may not. And it's important to have one. So we have a form that we follow. It's tried and true, and you will sign it and it'll be notarized. And what it does is, if something happens to you, you're in the hospital and you're not able to make those decisions about your care, long-term care, short-term care, whatever, you're incapacitated. You need someone to make those decisions for you, typically a spouse or a child or a very close friend or a loved one of some kind. Then that you designate that person in the healthcare power of attorney, and they can act for you when you're unable to act for yourself. And you can file those with the local hospital. You can give a copy to your doctor, all in advance, so everybody's got that if something happens to you. So we help you with that. There's also a financial power of attorney we talked about a little while ago. These are powers of attorney that enable whoever you designate as your agent to do whatever you can do. So if you're able to withdraw money from your bank account with a power of attorney, your agent can withdraw money from your bank account. So it's a very powerful document. It can be either durable, which means it's effective immediately, or it's effective immediately and upon your disability, or it can be a springing one that pops up, if you will, effective on your disability. So you can have it the way you want to do it. We talk about that. Not everybody wants one, but a lot of people do. And then the family home, so-called the Lady Bird deed. And right on cue, we've got Lady Bird Johnson popping in. And that's, of course, the former wife of Lyndon Baines Johnson, President Johnson. So funny thing, though, the Lady Bird deed is named after her, but she never had one herself. It was just an attorney in Florida came up with this concept to use these Lady Bird deeds, if you will, in the 80s. And they've pretty much taken off, and they're legal in Michigan and very effective in Michigan. And those work for the family home, work for most of my clients, a lot of my clients. And how it works is, say you and your spouse own your house together and you want to leave it to your children. Well, you can issue a Lady Bird deed and file that with the deed records now. And then years from now, when both you and your spouse have passed away, your loved ones, whoever you designated in your Lady Bird deed, automatically own the house. There's no reason to go, no need to go to probate. They already own it. And the nice thing about Lady Bird deeds is you can change your mind at any time. You can revoke those. You can mortgage the house. You can sell the house. You can do anything you want with it. The person that you're transferring that property to has no rights, zero rights in the property until both of you pass away. So Lady Bird deeds work pretty effectively to avoid probate and to make it an easy way to transfer a big asset like a home. And as Dorothy's here to remind us, there is no place like home. So you always want to take care of that in your estate. Steps in the estate planning process. Let's talk about that. And I'll go through these, a little bit of repetition from what I just talked about, but I want to outline these for you so you kind of know when you come into any attorney, this is probably what you're going to be facing. First thing when you come and see us is we'll have a initial consultation. So The initial consultation is usually by the phone. Sometimes it's in person, sometimes it's by Zoom, and it can be with me, at least partially, and then with Amanda, my legal assistant. She takes a lot of the nuts and bolts of the interview process and works with you. And I also talk to you, and we start getting an idea what sort of estate plan might work for you. And then we prepare, we give you some homework. We give you a checklist of your assets. You go through and you figure out all your assets, and we have a little form that we use. And this helps you really sit down and figure out what assets you have, and then make sure, boy, if I've got a life insurance policy, let me make sure the beneficiary designation is up to date. We help you with all those things. And we get a copy of your house deed. If you want to do a ladybird deed, we need a copy of the current deed. So we work with you on that. And then we work to prepare an estate plan that's right for you. We work with you and we talk to you about it based on your assets, based on your needs, based on your desires. We come up with a estate plan. And typically for most people, that includes a pair of wills, one for you and your spouse, includes a healthcare power of attorney we just talked about, includes the power of attorney for financial decisions if you want that as well. And it will also include the ladybird deed for your home. Again, typically, not always, it depends on your particular situation. Then we want you to review everything very closely. Very important that when we draft the documents, you go through that with a fine-tooth comb. And sometimes we go back and forth with emails to get everything just right. We want all the terminology, we want everything done just right. And then we'll come in, I'll either have you come in and do that, or we can do it by Zoom now. We can, I answer questions for you, and we come in and we get everything signed. And after that, we give you copies, and we provide you copies in a fancy little folder. Okay. And then a lot of people wonder, what do we do with our copies? What do we do with our folders? We give you as many copies and folders as you want. And I'll give you a little teaser on my, we follow the ladybird deed and deed records if you'd like us to. A lot of people aren't comfortable filing documents with the Register of Deeds. We do it all the time. So we'll file that for you as well and get that recorded. And then a little teaser I was mentioning, if you want to know what to do with your estate plan documents, I've got a little article on my website there. You can go look at that. And certainly we'll go through that with you if you come in the estate plan with us anyway. And then you're going to be so happy with your estate plan, just like these guys.
Success, success, success.
You'll see the size of the estate plan they had to carry around back then, right? Curly's got that big valise there. That's their estate plan, but they're happy. They made us a estate plan. They're successful, and you too could be successful. All right, Mo, we heard you once. And this is my favorite little saying, and I think it applies to so much of what we do in life. But do something today that your future self will thank you for. How many times have we thought about this and said, gee, I wish I would have done that last year. I wish I would have done that last month or 10 years ago. Well, your future self will really thank you if you sit down and do an estate plan. Until you sit down, no one likes to think about it. No one wants to worry about doing an estate plan. But until you do it, you know, it's something that you'll thank yourself for. So how much does it cost? You could be just like this guy, can't wait to pay. I appreciate that. So we'll talk about it in general. And keeping in mind that estate plans, they're not cheap, but they're not quite as expensive as this guy thinks they are.
$1 million.
It's worth $1 million, Dr. Evil, but we don't charge that much. Okay. So again, they're not cheap, but keep in mind these things. You may only do an estate plan once, right? If you get it right, you may need to never have to do it again. Or if you do have to change something, it could be as simple as doing a codicil, a little amendment to the will, much cheaper than doing everything all over again. It makes you focus and plan for the inevitable. We don't like thinking about the inevitable, right? But we're all going to go there. So if you sit down and focus and plan to make sure your loved ones are taken care of, what better way to spend your time, really? And it's not something you're doing for days and days, but it forces you to sit down and really figure things out and plan for your loved ones. And I always tell my clients, don't you owe it to your loved ones to make sure the assets are distributed the way you want them to be. And it gives you great peace of mind. Look at this young couple. They're so happy because they got their estate plans done. That could be, it does give you great peace of mind because you've got something done that you know you need to do. And you finally did.